Juniper myself. So I'm only 2 blocks away from you, okay? So
well, you can walk home from
I
the
can. Anyway, I did want to commend you on the fact that you're apparently making more of an effort to make sure that the sound is not more than it need be. The other thing I wanted to ask you, if I may, is how many of these events do you plan on having?
We usually have one a year. The one last year that you guys made an exception for, that was like a once-in-a-lifetime opportunity.
Okay.
We just always do St. Patrick's Day, and that's just about it. We don't do
Okay.
anything else.
Okay.
We did do, 3 or 4 years ago, I think we did one in the summer too. One of our girls that works for us had cancer, so we didn't have it for, other than that, I think that's St. Patrick's Day is pretty much the only thing we do with that.
Okay. All right. Well, gentlemen, I don't have any problem with it as long as we can not have amplified sound after 11 o'clock, and as long as you'll continue to walk around with your sound meter and take readings throughout, and also be reachable by cell phone,
Yes, sir.
then I don't have a problem
Sure.
with the application. Okay.
You want me to make the motion, Mr. Chair?
Sure.
I move we approve application 10-0055, Caribbean Jerks, Caribbean Durban, for a zoning permit for a special temporary use for charity event to be held outdoors with an intent Wednesday, March 17, 2010, from March 17, 2010, from noon to 1 a.m. with the stipulation that amplified music will be shut down at 11 p.m. The temporary use will be held at 1262 East Powell Road, Lewis Center, Ohio 43035, in the Oak Creek Center 1 commercial development, with further stipulation that Mr. Maselli be accessible by cell phone. And what was the other stipulation?
That he continued to do his due diligence with the sound.
And then Mr. Maselli continued to do due diligence to assess sound levels throughout the course of the trip.
Is that the motion? That's the motion. In that case, second.
Mr. Cassidy? Yes. Mr. Catt?
Yes.
Mr. Quigley?
Yes.
Okay.
Thank you.
Thank you. Okay, I think that puts us on to the park report. And the first item, I think, is pretty much mine. So, the first item deals with recommending a policy to allow for attorney fee reimbursement for future trail easements. As you may be aware, as part of our 2008 Parks Master Plan, we have been in negotiations with the North Point Meadows Homeowners Association and the Villages of Oak Creek Homeowners Association for various easements parallel to the railroad tracks for the build-out of our Lewis Center Rail Trail South. The negotiations have been slow but deliberate and constantly moving us forward in the right direction while addressing all the concerns of the affected parties. We're very close now to final sign-off from both those organizations. Either they or we have been in direct contact with their HOA council for review of final paperwork for their respective boards to sign. Which brings me to the point. Those reviews and work on behalf of the HOA necessary for them to grant the easements the township is looking for is going to cost them something. In the one case, reimbursement of those costs from the township to the HOA has been hinted at or suggested. In the other case, it has been directly requested, even before they'll proceed any further. To date, we have never paid for an easement. And even though this would be a reimbursement of legal fees so that the HOA is not having to put out of pocket to grant us the easement we are seeking, it still amounts to a payment being made to the HOA, albeit for several $100s to cover their legal expenses. So my suggestion and our discussion this evening will center around the following. Should we or not establish a policy whereby we offer to pay property owners up to $750 for the purpose of covering their verifiable legal expenses specifically associated with granting the township one or more easements? And with that, I will open this up to trustee deliberation. Mr. Cassidy, thoughts, comments?
Well, I guess my only question is, one option would be to establish an ongoing policy, but we might also consider just taking it on a case-by-case basis. And if the HOA, as has been the past experience, doesn't raise it, then we wouldn't be compelled to pay attorney fees. But if there's a HOA that we're dealing with, or a future property owner that we're dealing with that insists on it, then that can be part of our negotiation. But we wouldn't be bound by an ongoing policy. That was my only thought, is in these instances, could we just work the attorney fees into the part of the agreement for acquiring the easements?
We certainly could. I was only thinking that this would give us the leeway without having to come back each and every time. We would be authorizing the park liaison to have the authority to.
Right, you're looking at it to try and be proactive. So
Right.
that,
Exactly.
I understand.
So it's not necessarily saying we're doing this every time, it's more or
Not
less just saying
necessarily.
that if it is a request.
If it
we have
is,
the ability to-
correct. It's an authorization to allow, so we don't have to do it for each one.
I mean, I guess that I didn't understand it that way, so it makes me take a second look at the resolution. Because you can't really, a trustee board can't really authorize one trustee to commit the township to anything. I guess I questioned the legality of the wording of the resolution. I mean, I'm with you on what we're trying to do here. It's a good, I'm not quibbling with that. I'm just saying, is it something that we can look at on a case-by-case basis? Having it as a tool in the toolbox in current and future negotiations on the easement acquisition, rather than sending a message out to the world, hey, it's already, you're starting out getting $750 or whatever it is, and I'm just not sure.
Well, the only thing I'll say is that we have spent a huge amount of time even getting to this point with these HOAs, and you know, I would hate to see an easement go away simply because we were unwilling to cover the attorney fees.
No,
I don't think you're saying that. What you're
Yeah.
saying is that, I mean, obviously you're in the process, you're just saying, we take a step back and say, okay, bring
Right.
forward everybody, and let everybody make a determination on what they want to do. I don't think an HOA is gonna run away right away. If we just say, can you wait until the next meeting and we'll get back to you. I understand in this instance, yes, you spent a lot of time on it. This instance makes, you know, from your standpoint, you know, this is something you discuss now, whether or not we're gonna do it, but for future cases, I understand what John's saying, that maybe it's better just to, say, we're not saying no, but can we get back to you and have that discussion?
Well, we can do that. We don't have to set a policy. We can do it, like you said, on a case-by-case basis as people come to us and make the request. Or we think it's what will put the deal over the top, so to speak. But I've got one right now that will not move forward until we